English shorthand 120 words per minute. Legal dictation passages. Book code LPB-1 of National Shorthand School, Vizag. Passage number 23. Please get ready. Start. In the Supreme Court of India, Civil Appellate Jurisdiction, petition for special leave to appeal number 19,898 of 2014. D. Sudhakar, petitioner versus State of Andhra Pradesh and others respondents. Judgment by Madan B. Lokur, Judge. 1. The petitioner was directly recruited in the Group 1 services as a regional transport officer in 1990 and has been working as a joint transport commissioner since 2008. The petitioner belongs to the scheduled caste community and is physically handicapped although 2. The petitioner says that he has been unfairly treated for selection to the Indian Administrative Service, for short the IAS, and that he is entitled to the benefit of the quota for physically handicapped persons under scheduled caste category for selection under the Indian Administrative Service Appointment by Selection Regulations 1997. For this, the petitioner places reliance on the decision of this court in Union of India versus National Federation of the Blind and Section 33 of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995. 3. The background facts of the case indicates that the state of Andhra Pradesh had shortlisted the petitioner in 2002 for consideration for appointment to the IAS against non-state civil services officers quota. The petitioner was interviewed but not selected. Even thereafter, the petitioner was considered for appointment but was not shortlisted or selected. The petitioner says that in spite of the reservation for persons with disabilities as provided under Section 33 of the Persons with Disabilities, Equal Opportunities, Protection of Rights and Full Participation Act 1995, for short the PWD Act, which provides for 3% reservation for persons with disabilities in every establishment of the appropriate government. The petitioner was not selected in the IAS. 4. At this stage, it may be mentioned that there are 3 modes of recruitment to the IAS under the Indian Administrative Service Recruitment Rules 1954. These are A. By direct recruitment, B. By promotion of state civil services officers, C. By selection from amongst non-state civil service officers. The case of the petitioner falls in the third category, that is selection from amongst non-state civil services officers. 5. When the petitioner was not shortlisted for selection for the IAS in 2010, he approached the Central Administrative Tribunal Hyderabad bench by filing OA number 1297 of 2010, challenging the selection of 15 candidates by the selection committee constituted for this purpose that had recommended the 15 candidates to the Union Public Service Commission for consideration for appointment in the IAS. The further prayer of the petitioner was for a direction to include his name in the short list sent by the state of Andhra Pradesh under the physically handicapped quota and under scheduled caste category. 6. The state of Andhra Pradesh and the Union of India both contested the claim of the petitioner on merits and at law. It was submitted by the state of Andhra Pradesh and the Union of India that the concerned selection committee had fully examined the records of the candidates and thereafter did not shortlist the petitioner. As such, it was contended that the decision taken by the committee could not be faulted. the state of Andhra Pradesh and the Union of India also contended that the Indian Administrative Service appointment by Selection Regulations 1997 do not provide for rules of reservation for including a candidate in the zone of consideration. Therefore, apart from the contention that the petitioner was not meritorious enough, the submission was that even at law, the petitioner had not made out any case for interference by the tribunal. 7. The tribunal, by its order dated 28th February 2011, partly allowed the original application filed by the petitioner. The tribunal held that the short listing process by the selection committee was not at all satisfactory, and therefore the short listing of the 15 candidates was set aside as the selection was not fair. 8. With regard to the prayer of the petitioner that his name should be included in the short list, the tribunal held that on an earlier occasion it had dealt with a somewhat similar issue in OA number 998 of 2009. Accordingly, it was held that the petitioner had not made out any case for being shortlisted for selection.